The webinar will begin shortly. Please remain on the line. The broadcast is now starting. All attendees are in listen-only mode.
Hello, good afternoon. Now we have another round of online training session with Mr. Azhar on how to properly advise your clients on trust setup. And in this section, I think because trust is a very wide topic, we just cover on UDeclare. So maybe Azhar, you can go ahead. I change the presentation to you.
All right.
Okay. Okay, done. Go ahead, present.
All right. Hi, good afternoon, everyone. All right. I think everyone can see it. All right. This session about well, the title that I got earlier was how to sell UDeclare effectively. Okay. Now on this title, we'll look at a few things. Right. Before we actually go into what we call it, when to sell it or how to sell it, let's look at understanding UDeclare proper first before we go into the situations where you can promote UDeclare. Now, firstly, this UDeclare, it has got two documents in there, which is a power of attorney and a trust deed. Okay, so these two documents combined together makes up what we call UDeclare as the product. Now, the structure of the UDeclare is like this. Your client is the settlor. What he will do is in a UDeclare, he will appoint himself as trustee. All right. Then also at the same time, he will appoint Rockville's trustee as the trustee. Rockville's become the substitute trustee. Both Rockville's and your client is actually holding the assets that he put inside UDeclare for the beneficiaries. Usually, the beneficiaries will be when the client's alive, 99% the client will benefit. Okay, 1% will be other beneficiaries, which could be his wife, children, or someone else. And then upon his death, then it will have other persons being the beneficiaries. Okay. Now, I mentioned on top here that you can see here in the slide, Rockville's has a substitute trustee. When do actually Rockville's act as trustee proper? Rockville's act as trustee proper when the settlor dies or when the settlor suffers TPD or coma. Rockville's will take over the assets inside the trust to act as trustee. Okay. Now, the simple diagram to illustrate how UDeclare works. Now, what are the features of UDeclare? It'll be like this. Number one, this UDeclare is revocable, meaning that your client can cancel or amend it before death, right? The settlor, while acting as trustee, retains control of the trust asset. So he never loses control simply because he's the trustee and Rockville's is the substitute trustee. Now then what will happen next is that Rockville's trustee, acting as a substitute trustee, will ensure that the trust continues and complete the entire trust upon death or disability of the client. Right. Now, however, do take note, it is UDeclare, it's not protected against creditors when the client become bankrupt. Okay, simply because the assets are still in your client's name, it was never transferred out, and this UDeclare is always revocable, it's never irrevocable, so protection against creditors is not provided. Okay. The other feature to take note about UDeclare is that the only West Malaysia assets can you put into UDeclare. Alright, okay. It can be movable assets or immovable assets. Okay. If it's a landed property, it can still be owing to the bank, it's still fine. What happens that different assets, you could have mixture of property, money in bank account, unit trust, all go into one UDeclare, provided it all goes to the same group of beneficiaries. Okay. Now, listed shares, however, that is under the CDS account, we can't put it under UDeclare because there's some issues with Bursa recognizing the power of attorney that we have provided. Okay. But do take note, we don't have such problems when we deal with banks, unit trust companies. We have used that power of attorney successfully to recover the assets for distribution purposes. Only at Bursa there are some administrative issues at the end, which remains unresolved. Okay. Now, what are the common assets people will put into UDeclare? Commonly, people will put in unit trusts, Sundram Bharat company shares, monies in bank account, life insurance, which is usually mixed with other assets such as unit trusts, shares, or bank accounts, and sometimes in very special cases, properties. Yeah. Now, the next thing to note is that, well, how do you sell UDeclare effectively? Now, to sell UDeclare effectively, firstly, we take note is not everyone needs a UDeclare, right? Just like not everyone needs an insurance trust, because usually when you introduce UDeclare to a client, if a client will ask you, why do I need it? If you can't answer, that will be a bit embarrassing. So you need to find a reason to introduce UDeclare for the client and a reason for the client to buy that UDeclare, right? Now, so we need to identify when is UDeclare actually required. From there, then you can sell UDeclare easily, because what you're doing is you're doing a service to provide a solution. We are not selling a product, right, to the client. This product is not fixed. This product is got some basic features, but the solutions can be customized for the client depending on the situation. All right, if UDeclare the answer, then we can customize it. So it need to be sold when you identify the situation. For example, right? Number one, getting back your property. Now, there are people who, what we call it, sometimes buy property under the names of other people, right? Okay. So in this case, you have a client that tells you that he bought properties using his sister's name, okay? So in this case, what can we do? Because this client of yours is worried when the sister dies, it will become part of her estate. Okay, so tell the client this. Number one, legally, that sister is the absolute owner of the property, right? It could be seen as if you are just helping her to pay for the property, right? Two is if she dies, or rather when she dies, the property legally belongs to her, belongs to her husband and her children, because the property is registered in her name, all right, and it's not actually the client's anymore. Right? Now, if the client, if the sister is in a coma, then the client is stuck. If the sister suffers TPD, then you're also stuck, because she may not be able to sign any documents to transfer it back to you, or she may not have sound mind. Now, and finally, she can also refuse to follow your instruction because the property is in name. Because right now, the relationship between brother and sister is pretty good, so they have this trustworthiness going on, which this trust is rather fragile in that sense, that relationship. So how do we protect your client who is the brother? All right, UDeclare will be the solution, but how would you structure the UDeclare to provide the solution? It will be like this. Yeah. Now the sister will become the settler of the trust. She will appoint herself as the trustee. She will appoint Rockville's trustee as the substitute trustee. Right. And when she dies, Rockville's will act as trustee, or when she's TPD or coma, Rockville's will act as trustee. Okay. Who is she acting as trustee and Rockville's holding for? Who's the beneficiary? In this case, it would be 100% the brother. All right. Failing which, in the event the brother passes away, it will be the brother's wife and children. Okay. Now, in this type of UDeclare, when we do, we have to customize it to say that the right to revoke or the right to amend the UDeclare is only given to that brother. The sister will no longer have any right. The sister is just the party creating this trust, that's it. All right. Now, in addition to setting up this UDeclare, what we require the brother to do with this. Now, we will want the brother to buy insurance policy for himself and also pay for the insurance of the sister. Why? Because of this. Now, in the event the sister dies, suffers TPD and coma, that insurance money, right, can be used to go and settle the loan in full for the property to be transferred to the brother or to the brother's wife. Now, in the event the brother is the one who dies first, then that insurance money can be used to settle the loan properly and then to transfer that property to the brother's wife insurance. Okay, because if not, if you don't have this insurance, you will have an issue. Who's going to pay for the loan, and the transfer will never be done. Okay, selling it is also going to be a problem because finding a buyer takes time. Getting the buyer to get a loan that he qualifies for also will take time. So that would definitely take more than 3 months. By that time, the bank would have forfeited the property, sold it off for under auction. Right? So we don't want that to happen. So in order to prevent that from happening, the insurance is important. Okay, at least to buy time to pay for the loan, or to get back the property to be registered under the brother's name or the brother's wife insurance name. Now, then, in order for the brother to prevent the sister from selling the property or refinancing the property without him approving it, okay, we will ask the brother, you need to lodge a caveat. Now, this caveat is going to be, it's going to last for 6 years, and it's also renewable at the end of 6 years. The good thing about it is that in the event the brother passes away, the caveat will die with him. All right. So this will allow Rottweils to do the necessary, after paying off the property, doing the redemption, to transfer the property to the brother's wife and children, in the event the brother dies first. But then the other situation of using UDeclare would be this, that is when there's minors involved and dependents involved. The dependents could be like this, could be age-old parents, could be handicapped children that the client have got, right? This would apply to clients who are married with the husband and wife or single parents, okay? Because what happens is that when the client is dead, in coma or disabled, your dependents and your children still need to live on, right? They still need money to live on. So how do we make sure that they have money to do so, okay? Now, tell your clients, even if there is a will, distribution following the will take at least 2 to 3 years to be done. So if your client have got tax problems, some undeclared taxes, or because he's a businessman and then he decided to pay less tax and do some funny tax evasions, then it will take even longer because the tax department will do an investigation of the years of tax, the amount of taxes that he paid, to find out whether there's any amount that should have been paid but was never paid. Okay, so that investigation will definitely prolong the distribution, which could take now probably 5, 6 years, 7, 8 years. Because I've got cases that take sometimes 4, 5 years because the client didn't pay tax during his lifetime, so they were all investigating. The Inland Revenue even asked us to resubmit the earlier years of assessment, right, where we have got no idea what the income and all that. So it adds on to the total delay suffered by the beneficiary before they receive any inheritance. Okay. Now, at the same time, because it's going to take 2, 3 years, what is the children and the parents going to live on, right? Because all assets are stuck. Assets are all frozen. It will take some time before they can be released, right? Sometimes the other problem is sometimes there may not be any assets left as well because all of it is going to debts and cost of this and cost of that, right? Now, if the client is in coma or TPD, is there money for the maintenance and medical needs of the client. If there's none, if you didn't plan for it, then you're stuck. All right, then you have a problem. What about putting food on the table for the children and the parents? All right, if you didn't do any planning, now they are stuck instead. All right, they will suffer. They will suffer that financial hardship. All right, okay. Now, what can we do as a solution is to do this: is to ask the client as a settlor. He appoints himself as trustee. He appoints Rock Will's trustee as the trustee. Okay, and the beneficiary in this case would be the client himself. 99% settlor, 1% is to children and his wife and his parents, for example. Upon death, all of it could go to his wife, children, and parents. Okay, and as usual, Rock Wills only come in when the settlor dies, TPD, or in coma. Right? In the trust deed, we will say if it's TPD and coma, a big chunk of it, as you see in the slide, okay, where I'm pointing, what will happen is that the settlor will become 99% beneficiary. He will still benefit. Yeah. Now then comes a situation where you have this, where you've got people sharing to do property investments. All right. Okay. When clients invest, this is where your client invests with different partners to buy properties. Sometimes some of those properties don't even have your client's name. All right. Because the property market is booming and all that, so your client invests in it, wanting to make a quick buck, right, within a few years. Tell him this: you got this problem. One, if all the partners have names in the property, then when one of them suffers TPD or coma or dies, then the client and his partners will have this. They are stuck. Reason why they're stuck is because you're missing one person having to sign documents to sell the property. That's why you're stuck. All right, okay. At the same time, you're stuck also because you have to continue to service the loan. It's more burdensome on the surviving partners. So instead of 3 people sharing, for example, now it's left 2. Or if there are 2 people sharing, now there's left 1. So you take the burden. The problem with this is that it's not one property. It could be 5, 6 properties, all right, that you end up with this kind of situation. So it's really burdensome. Now, if you don't have a name, all right, on the SMP agreement, all right, that means you use your partner as the nominee, and then your partner dies, suffer TBD or coma, what the issue? Just like the brother and sister, legally, the partner is the absolute owner, all right? When the partner dies, the property is legally belong to his wife and children, not yours anymore. When it is coma, you're stuck, or TPD, you're stuck because you can't deal with anything, right? He may even refuse to follow your instructions. You're also stuck because again, the relationship between you and your partners are, you base it on trust, which can be a very fragile thing and can change over time. Okay. Now let's take a scenario where the property is not in your client's name, which is similar to the one under brother and sister name, okay. So the solution is the same as that, all right. But the bottom part is a bit different here. The beneficiary, because the client is buying these properties, has investments rather than a place for him to stay. All right. So what will happen is that for planning purposes, it's probably good to do this. First option: partner dies or client dies. All right. Depending who dies first, TPD and coma. First option is the remaining owner buys over the deceased portion. An offer is made to the remaining owner. Why not you buy over deceased portion? Or the partner who suffers TPD or coma. Now, if let's say that partner doesn't want to buy because say I also got no money, you can go with option 2, which is the remaining owner go and find buyers, all right, within 3 years, all right, and then when you found the right buyer willing to pay the right price, then Rock Wills can sign the sale and purchase agreement, okay, on behalf of the deceased to sell off the property, assuming the deceased is the partner here, right? Now, to amend this type you declare, then we will say that both the partner and the client need to agree to sign, to revoke or to amend the you declare. Cannot be just one party, right? Now, this situation also will require insurance to be put in, all right, under the client's name and under the partner's name. Okay, so so long as either one passes away, TPD or whatever, Rockwool will use the money instead of now settling the full loan, like the brother and sister case. Unlike the brother and sister case, we will use the interest money instead, just to pay for the monthly loan amount. So that means the sum assured required for this scenario is just enough money to pay for 3 years installment on your client's portion, all right, okay, while waiting for a new buyer. So they actually got 2 policies plus properties in there. Yeah. Now, at the same time, because the property is not in your client's name, it's best that he lodge a caveat to prevent the partner from reselling or refinancing it without his approval. Now, what if the property is in the client's name together with his partner's name? So what will happen? Very much the solution is more or less the same. All right. Okay. Both of them, instead of just one of them now, both of them are settlors. Jointly, they're settlors. They appoint themselves as trustees. Rockwool is a subject trustee. Rockwool will come in when one of them no longer around to handle that person's portion. The beneficiary will be like this. First option, let's say co-owner A, Mr. A died. Rockwool will offer to Mr. B to sell Mr. A's portion to B. If Mr. B say, I've got no money to buy, okay, Mr. B can look for a new buyer within 3 years to sell off the entire property too. All right. Now then, after that, then less all the loan amount and so on and so forth, the net profit will be shared 50-50 among the partners, or whatever portion that have been agreed upon earlier among the deceased partner's portion and the surviving partners himself. All right. Again here, both need to agree to revoke or amend the UDeclare. Now, the insurance is required, just like the earlier version, to pay off the monthly loan amount. The amount suggested here is 3 years, enough for the loan payment. Now, there is no need to put in a caveat because your client is one of the registered owner. So any refinancing, selling, or whatever requires your client to consent anyway. So that's fine. Yeah. Now, how will I know, or rather, how will I know when to, not to say, how do I have, how do I get clients to tell me those kind of situation, those few examples just now, right? Okay. One of the ways for me to be able to get such information from him so I can introduce to him UDeclare. Now, your ways are pretty simple. There's no magic wand or no magic to it. First thing is you have to get a will client, right? You have to get a will client. Now, a lot of people think sometimes getting will clients, well, they just do will like nothing else. I can't tap on nothing or anything else. Actually, there's a lot of things you can tap to when you have a will client. Because the more will client you have, the more data you will have, the more family situation that you have. When you take instruction from the client, he'll give you detailed instructions. Now, if he doesn't want to give you detailed instructions, then you tell him, okay, we may not write such a long will, but let me have an idea what are the assets that you have. We'll see what can be combined, right? Okay, so that your will, you don't want it to be too expensive, but there are sometimes certain things in there that we may need some additional planning. So the will instruction he gives you, you need to analyze that data, all right, okay, that you get to see whether, okay, has everything been planned out earlier or there are a lot of gaps, right? For example, they say, oh, you see in the will, he's got young children, okay? Automatically, it tells you, looking at the, what we call this, looking at the second example, all right, where you're providing for dependents, he needs to do UDeclare and you can tell him why. And sometimes the conversation that you tells you during that will instruction taking, right? It creates a bond between you and him for him to trust you more, to tell you more, all right? Which allows you to probe for more information to be given to you, for you to be able to provide a proper solution. And if your insurance, you're lucky, you may be able to get to sell more insurance, yeah? But sometimes when you're insurance, agent, you want to sell insurance to your client, he may be just willing to tell you my budget is only X amount, right? You will not have a chance or excuse to ask him his family, his assets that he has got, and so on and so forth. So you don't know a lot of things. But with what we call this, with this, right, with wills, you can ask for those things. You have an excuse to ask. Yeah. Okay. Now the second step to do would be to go through your existing client list that you may have. So if you're a company secretary or you're an insurance agent or financial planner, you have lists of your existing clientele. Then more or less, you have some of the background information already. So you could approach them, get them to do a will first, and then from that conversation, get to know the client better, and then zoom in on the areas that he needs a trust for. All right. Oh yeah, I forgot one of the things you could tell a client, because you got this debts and that debts, it's always good to have a trust, if not for your family members, so at least use that trust to settle some of your debts, like property loan, car loan, and so on and so forth, and credit card and all that. Yeah. Now the other bit is, once you have done a good job for your existing clients, you will get referrals from your existing clients, right? Because your existing clients know that you have done a good job for them, they're more willing to give you referrals, right, for you to get new clients and so on and so forth. Now, finally, you can do networking, of course, with insurance agent or real estate agents in this case for property investment bit, all right, so you get more clients, all right. But always start with the will bit, then follow up by the trust, because it's very difficult to sell trust to a client, since most members of the public have got no idea what is trust. If you say the word trust in Chinese, it sounds like unit trust. And this client may not want to listen to you if you're selling unit trust. Now, what is the advantage of having a trust? The advantage should be this. One is the assets in the UDeclare are quickly available, immediately available. It doesn't have to go through probate. Right? It also gives you protection over your assets and also your loved ones, because if your assets are in someone's name, then now with this UDeclare, it protects your assets and it protects you, and also to ensure that your loved one will get those assets that you have in someone else's name. Okay. Now, because UDeclare doesn't have to go through probate, right, and the money can be quickly available for the children's maintenance and so on and so forth, it will actually prevent the guardian suffering financial hardship to take care of your children. All right. Okay. Now, at the same time, because you've written everything nicely clear, all right, your beneficiaries who may be left out, who's not happy that they're getting very little and all that, can't really challenge the trust, because a trust is a lot more difficult to challenge than a will, because a will, you can even do it very last minute and there's nothing else that you need to do. Whereas for a trust, there are a lot more documents that need to be signed. Like, for example, the UDeclare, the power of attorney, and if it's the living trust, the client need to transfer the assets to the trustee, right? So challenges are very difficult to do, right? Because a lot of it is done during lifetime, requires verification of commission oath and this and that. So a lot more difficult to challenge. Whereas the real last minute forgery can happen easily, all right? And I think this is true if you look at the papers. You do not see any report on trust being challenged, but you see a lot of cases where wills are being challenged. Okay. Now, also because UDeclare is revocable, it's flexible enough to meet the changing circumstances for your family. All right, in terms of relationship with the beneficiary, now it's turned sour, you want to change, or has gone better, now you want to give more, or your client have got more children, all right, or a new wife, a new spouse, this sort of thing, or the client have gone through a divorce. You can make amendments to the trust. Okay, just like wills, UDeclare will allow your client to choose who he wants as beneficiary, and the way you want to give it to your beneficiary, whether you want to give one lump sum, you want to give periodical distribution, or you want to state conditions to be fulfilled before distribution is made. All that can be done. Right, as mentioned, you retain control as trustee. You retain control over the assets as trustee. So you are going to be very comfortable, because you don't pass any assets to Rockwells at this moment when you're alive. Yeah. Okay. So that ends my short session on UDeclare. All right. It's not meant to be a very long session because there's supposed to be Q&A and all that.
Yeah. Yeah. Actually, I show my screen. Let me see. View. Okay. Yeah. So actually, thanks, Ijazah. So the information I gather is to sell UDeclare is very easy because you need to identify your market, and UDeclare is actually not for everybody.
Yeah,
right?
correct.
Okay. So I just want to ask is this case for Muslim or only for non-Muslim, or in such case there are combination of Muslim and non-Muslim?
It's very much for non-Muslim only. Because
Non-Muslim.
yeah, because UDeclare is not designed for Muslims. You will not be able to avoid. You will not be able to avoid for it.
Okay, so 100% this is for Muslim lah, huh? So we narrow down a bit. So just in case people were asking, so this is for Muslim only, non-Muslim no. For non-Muslim only, okay.
Correct.
Muslim only, okay. Okay, then
Yeah.
how many UDeclare cases so far that Rockwell Trustee handles? I mean, set up.
We'll set up about right now about 2,000 plus, 2,700 plus, I believe.
Or 2,700 plus. So
Yeah.
out of this 2,700, how many percent roughly are people that set up because their assets are in other people's name? How many percent set up because they want to protect their dependents? And how many percent they set up because due to this property investment?
About 10% for proxies. Then about 80, what we call 90, not 90,
90,
sorry, not 90, about 80,
89.9
well, 89%, about 89%. Yeah, then 1% is for property investments because there are not that many people doing it, but there is a need to,
There's a need to, but I think when people look at, I mean, for property investment, I think their mind is about making money. This part is like protection part. Their mind is not towards the protection. From the case that we propose, quite hard to close. Right?
But we have done some, when they understand, yes, it's important, they don't want to get stuck. So sometimes it's catching them at the right time now also.
Yeah. So I think, is it fair that, maybe I ask my associate to focus on this type of this bucket, which is dependent. They have dependent and then minor or elderly.
Yeah, and
so
then the proxy one, the proxy one also same.
Middle class executive with young children,
Correct.
Children. Maybe I ask them to focus on the middle class executive with young children, or what, businessman.
Yeah, businessman
with young children. I would say that maybe single, is it? Single with
single
aged
parent.
mother. Single parents with young children. Fourth is like maybe with people.
What do you call this? When you have aged parents, aged parents or old dependents,
Yeah lah. So this 1, 2, 3, 4. So I think we target this lah. As long as they have young children, either middle class, businessmen, or single parents. Then
but you have to take note, if their client is too rich, like a tycoon and all that.
Tycoon.
I think getting them to set this kind of trust could be a bit difficult because they say, well, they've got money. I've got money, my wife has got the money, so it's more difficult to convince. Like you say, having the middle class one, they're more concerned about it. Yeah, they're more willing to. Middle class, upper middle class lah. Right.
Middle class, upper middle.
Yeah.
All the ultra rich tycoon, we don't propose this right? I mean, very hard to close
It is difficult, spend more time. They're more skeptical than anything else
Okay lah. So we target this part, this part middle, or as long as they have young children and they are concerned on all the liquidity right?
Correct. Yes.
Okay.
Young children also special child
Special child. Yeah. Young children. I think special child family with special child.
Special child.
because they are not capable, right, financially to handle
Correct.
money.
Correct. Yes.
So in order to close this, right, we target on these few segments only.
Yeah.
Okay, so for my associate. Besides that, I think I need to open to unmute Amanda first. Amanda, hello? Hey, Amanda, Homa. Amanda. Amanda?
She's probably somewhere
Hello.
else.
Ina. Where are you? Sorry. Oh, on the other line. You got question or not, Amanda? No question. I mute you back. Okay. So actually, in order to, I think we go through the form lah, right? Malaysia Wheels. If you go Malaysia Wheels, it's a secured place lah for the franchisees. Here, click franchisee site. But actually no. I restructure my website under Malaysia Wheels. Yeah. So on the right hand side, you can see all this free online training. Then you click here, our unlimited training resources is accessible to members only. Then you come to this page, and then existing partners. You click existing partners if you are our existing partners, and you will reach this secure page, secure site. So in order to get the form, you go to fees and form, and then you scroll down until you see here trust instruction form in PDF format or trust instruction form in document format. So in Azhar, we normally put in document format, right? Because we want a soft copy. So this is what we do, right?
Yeah.
Document
Okay.
format. Okay, let me roughly go through the trust instruction form. So the first thing is, use block letters, okay? Mark X wherever is relevant, okay? So this is the franchisee's detail. And then for this, you declare, so we tick here lah, you declare, right?
Correct.
And then for you declare is revocable. So it's you declare, then we tick revocable. And then we put here the preferred name of the trust. So we type in here, what is the trust name?
Yep.
So
right.
normally we put maybe family trust, but trust for Mr. Maybe
Could be the name. It could be the name of client, Tanakau Family
name.
Trust, that kind of thing.
Yeah. Okay. And then state the reasons for setting up the trust, like protecting minor children, protecting aged parents, right?
Yep. Correct.
Basic reason, or protecting special child. We go back to all this lah, right? Protecting, the children, protecting aged parents or special child. Then after that, if the client can understand English, then just tick yes lah. If no, then tick no, and then state down what language. Okay. And next is the client's personal detail lah. Okay. So this is easy. Gender, citizenship, marital status, employment, address of employer, business. Is this critical? Is this like very important? Must fill up? Have to fill up.
Which one is this?
This
The
employment.
Yeah, we need it for our anti-money laundering to know the source of funds of the client. Where does he get his money from?
Okay, so you must lah. So this one is must fill up.
Correct. Yeah.
Then
so if a form is given to us, without this, then we will ask the franchise to tell us so they can fill it up and all that.
Yeah, lor. So this one must fill. Okay, now we know again. Please send all my correspondent to. Normally we tick here lah, to the professional estate planner, right?
Yep.
Normally lah. Okay. And then just now you mentioned the protector, because the protector acts as a watchdog. Okay. So protector power is quite huge. So we have like 1, 2, or 3. You can choose to fill either you have 1 protector or 2 protector jointly or 3 protectors, right? And the relationship. Yeah. In here, I have a question. Can the protector be a Muslim?
Can.
Can the protector be a foreigner? Not Malaysian?
Not much of a, unless it's located in Malaysia. If it's located somewhere else, kind of pointless or meaningless for him to be the protector.
Oh, okay. So based in Malaysia, but it doesn't matter lah. What's the citizenship?
Correct.
It doesn't matter what's the religion also lah.
Correct.
Correct, huh? Good. And then the protector, if it's paid allowance, normally yes lah. Because if not, then quite,
Well, usually no, actually.
usually no ah. Wow,
Correct.
so good one ah.
Yeah.
Okay, and then usually no. Okay, so important information required for this you declare. So normally people would take total permanent disability, critical illness, comatose, or resignation of settlor as trustee lah. Death
Correct.
is an automatic triggering events.
Yep.
Okay. And then others. What are the other things that normally people put in triggering event? Normally no, right? Normally basically
Sometimes got lah, depending on, because sometimes for the franchisee, they may not know how to fill it proper. So anyway, you fill up those things. So then when we look at the entire form, is there a need to add in extra additional? Then we'll add in additional and make suggestion lah.
yeah. Okay. I have a question. When we assign the insurance policy to Rockville trustee, what if the client said that the triggering event is I want total permanent disability, comatose, and death? I do not want critical illness to be the triggering event of the trust, but the insurance policy is already assigned to Rockville trustee.
Is
So
there a
what
trigger?
happened here?
Is there a trigger? Is there a critical illness coverage in the policy?
There is critical illness coverage in the policy, but he doesn't want, because after when he has critical illness, he wants to benefit it in a lump sum. He doesn't want the periodical payment.
And so long as it's not dead, so what happens is that as long as it doesn't cross that, yes, the policy assigned to Rockville, we will go and
Yeah,
claim
yeah.
it, then we'll give it to him lah.
Also, in here, we don't include in the trust instruction form, lah, right? Or we
Correct, yes.
include.
We don't include, no
So
need
we-
to include.
So the client take total permanent disability, comatose, okay, death is automatic. So we leave this critical illness open, but the trust,
Right.
the insurance policy has critical illness element in it,
So
assigned to
yeah,
Rockville trustee.
so we give the money to him, but then the other assets in the you declare, for example, bank account,
Yeah.
that one we will have to recover it lah at the end of the day if he
Yeah lah.
doesn't take it, if he doesn't take it. So
Yeah, of
or
course.
if he's not able, then we will take it and all that. So it's something that need to be discussed also at what point he wants us to take. Usually critical illness client don't put in so much. It's more of
Yeah.
those where they cannot really go to and deal with things anymore. So more of TBD and comatose.
Okay, yeah lah. Then the critical illness part, right? If the payment, the insurance money come out and paid to Rockville trustee, and Rockville trustee paid to client, the charges, is it 2,000? You have the trust.
Yeah, we
fund
will charge.
will not
Yeah, correct. We will charge that
2,000,
2,000.
Okay,
Correct.
good. Okay, that make it so clear. Okay, so this is a revocation of you declare. So who can revoke it? So during the lifetime, it will be the settlor lah. Normally the settlor is the one revoking it.
Correct.
Right? Settlor and trustee. Seldom we have beneficiary. Seldom we give beneficiary power to revoke the you declare.
Seldom, because they could, I don't know, they could do all sort of things.
Yeah. So next is future changes of you declare the terms. Normally it's settlor lah. Normally put settlor.
Normally it's that law, yes.
Future changes means if let's say before the triggering event, right? The future here means
It
means
could
after
be-
setup, before.
It could be after setup, after client die even, or before client die.
Oh.
So it could, so long as
these two
during
lah,
trust
use that.
period. So during trust
so we
period.
take we take two lah, right? Just in case for the flexibility of the protector.
Correct.
Okay. Okay, so in this important note, you highlight red color. I think this is more towards the anti-money laundering, right?
Yes.
Because you want to know who is the effective controller. Because right now, the you
Correct.
declare can be used for if your asset is parked under someone else's name.
Correct.
So effective controller in relationship to a settlor means the natural person who ultimately owns and controls the settlor.
Yeah.
On
Just
behalf
like the
of the
brother.
transaction.
Yeah. This is the like the brother and sister thingy lah. Somebody owns your property lah.
Okay. So if let's say there's the effective controller, then we need to fill up. This is very important, right? If not, you won't take up the case.
Correct.
And then all these things, percentage of share, relationship to settlor, years known to settlor, okay. Then here is the trust period. So the trust shall end upon the trust fund being exhausted. Okay, this is understandable. And then apart from that, choose on the either you want to choose a fixed period or you want to maybe until a particular event happen. What is the normal period people choose in here? I
What's
think
the
it's
period? It depends.
yeah,
If
like
it's
for
for
example,
if it's for family, means it's usually
for young children.
yeah, it's usually for until the children reaches a particular age.
Yeah,
If it's for HO
yeah,
parents, it's usually until the parents pass
parent passed away.
lah. Correct.
Yeah, yeah, depends. And then detail of trust assets. These are the information and documents needed in order if you want what are the information what are the assets that can be put in the trust is like shares in St. John Berhad law or landed property law.
Correct.
Okay, but landed property there will be stamp duty involved on the transfer, right?
Yeah.
Pay upon death, right? Pay upon triggering event, pay upon transfer.
Correct. So all those are to be noted. Those are costs that will be incurred in the future lah.
Yeah. So bank account also, you need the account number and bank and branch location. Unit trust,
Correct.
investment. Do they need to photostat the front page of the what bank's account book?
We just need the statement lah.
trust.
If they have a copy of the
Oh, the
statement, so
statement,
that we just want to make sure that we don't give the wrong what you call this lah. We don't give them a wrong number lah.
Okay, good. So next is for joint property owners or joint account holder, they must be joint settlors lah. My question is, if let's say all the assets right belong to sole, but only one bank account is joint. So in this trust instruction form, do we do a joint or how do we structure this? If let's say everything is owned by Mr. Tan Akau, except for one bank account which is he also want to put in this trust, quite substantial, which he and the wife jointly own. Do we do a joint trust UDeclare or
Yeah,
we do
they would have to they have to do a joint trust already.
under one? So under the joint trust, there will be assets under the Tan Akau sole name and one asset is
Correct.
joined with the wife, is it?
Yes.
Oh,
Alright.
can lah, means can put under one.
If not, then what we call this? If not, then they will have to
Separate.
they will have to separate things out already.
What is the recommendation here? What's the recommendation?
Recommendation to do what? Sorry.
To separate or to sold?
Depends on how much is in the joint bank account. If there's not much money there, we'll tell them no need to put it in. If it's substantial,
It's substantial?
then maybe they do it separately lah. A separate UDeclare.
Oh, okay lah, we do separate. And then this one is of course we key in the movable asset lah. Okay, and then here is the immovable properties. And then here are the properties, okay. And then what's this? Allocation and distribution of trust fund during the trust period to pay the debts, taxes, estate admin, legal fees. So these are the percentage of Ringgit Malaysia, the money allocated right, for funeral expenses, housing loan, high purchase loan, credit card loan, personal loan, outstanding debts, solicitor fee, expenses, and disbursement incurred by Rockwood trustee and executor, and then part of the trustee fee, okay, and other things.
Correct. Yeah, if their client wants to put that in lah. If not, then it can be left out.
Yeah. So entitlement and distribution is fixed or discretionary. They want to. So this is talking about distribution. Okay. So you need to put in all the details of the beneficiary. So
Correct. The name, ID, relationship, date of birth, address, and
percentage.
what portion do you want them to be entitled to under the trust?
Yeah. So for this type, it's also the same as protector, right? It can be. It's not limited to any religion or any citizenship. For this.
Yes. Can be anyone. Can be local. Can be foreigner.
Anyone. Okay, good. And then this is the beneficiary on the distribution instruction. Okay. You want to customize lah. Here is about customization already, right? Because here you put in the percentage, and then here you want to customize it, right? Every month.
Correct. How do you want to give it out to the beneficiaries?
Okay. Okay, and then this is distribution at the end. So at the end of trust period, if there are still some balance remaining, this is how you want to distribute it, right?
Correct.
You want to distribute it proportionately or equally, right, to all surviving beneficiary.
Yeah.
Or if you have
correct.
additional instruction. Okay. And then also, of course, please inform the client. Oh, this one you have trust set up, the deposit. I thought it's one lump sum. I thought the fees is
There is
pay.
a deposit of 1,000.
Oh, okay.
So if the trust setup is only 1,000, because how they will calculate, if you look at the form, there's this alias signs.
Yeah lah.
So when you add it all up, that will tell you how much to charge the client.
Yeah, and then I want to ask, normally for this type, generally lah, how much is the quotation like? For people like
It's going to be between 1,000 to 2,005, depending on how lengthy they want to do it.
maximum is 2005 lah. So is it safe? Let's say if
I
my
wouldn't say
our
maximum
associate,
2005. Hang on, it's because it's very difficult to say it's maximum 2005. Some clients got very long instructions, right? So the best is to calculate, take the instruction, calculate, and tell the client. But if the client want to have a figure, then okay, it's between 1,000 maybe 2005. But again, all depends on how long your instruction are, right? The longer your instruction, then when I use the form, then you may get to charge more lah. All right, those sort of things. Otherwise, they get caught and then they got problems afterwards.
Oh, yeah lor. Yeah, because the client will surely ask about this, and then that's why we need to be, we need to know the ranges. Roughly,
Okay.
if let's say this, about one, we say don't say 1,000, maybe say 1,005 to 2,005.
Okay.
That we, husband and wife is 4,000, something like that. We say.
I see. Well, around there more or less. But don't scare them with such a big figure first, because sometimes they, they'll get put off when they hear too big an amount.
4,000 is okay, right? Too big. Husband and wife.
It all depends, because some people to them it's a lot.
Okay. And then identification of documents, required documents, we need to verify that. And then these are the information that we need to also tell the client, right?
Correct.
This one. Okay, the assets in the trust can be still under loan, right?
Assets in the trust,
Can be still under loan. Like,
still
for
under
example,
loan,
properties,
yes. Correct.
right? So for all these
Correct.
properties under this one under loan, yeah. And then okay, all this fill up already, understood. The settlor will need to sign, witnessed by who? Professional estate planner to sign, and then collect the money here. If there's insurance, then 20 ringgit per policy, payment check to Rockwood Trustee Berhad or credit card.
Yeah.
So this is the trust setup fee. So when for this declaration of trust, there will be standard from just now we quote 1,005 to 3,000, 2,005 so it will be around 15 to 30 clauses. Okay?
Yeah, I'm sorry. It starts from 1,000 to 1,000 or 2,005 lah.
Yeah lah, 1,000, 2,005. Okay. Then these are the annual trust administration fee that we need to communicate to the client also, just in case they put their money in the trust. Actually, don't ask also, we should communicate, right?
Say again, sorry?
If they didn't ask also, we should communicate, right?
Yeah, usually they will ask. Usually the client would ask.
Yeah,
the client won't be quiet about that.
Yeah. So we tell them lah, then we calculate for them.
Yeah.
And then the holding company, this one how much we will charge, 8,000 for holding 3 companies. Okay, with the same shareholder, right? These 3 company, this 8,000 is the same.
Yeah, correct.
Shareholder. Okay, so immediate distribution is 2,000. So just now you mentioned, if let's say you receive a lump sum from the insurance and you distribute immediately, it's 2,000.
Yeah. Sorry, when you say the same share just now for for B and C, it doesn't need to be the same shareholder so long as it is your client's share. All right. What I mean is the three companies need not have the same shareholder. That's only for buy sell. That's only for buy sell. You want to merge it together. Here, so long as your client putting the shares from three companies inside one buy sell, inside one trust, and you declare, then it will be 8,000 in the future lah. Right? I don't care about the three companies who are the actual shareholders, but if your client got share in there, he puts it in the you declare. Right? Okay, so it's more of his shareholding in how many companies.
So in the future, if the client pass away, then Rockville trustee will be shareholder lah, in that company lah, ABC.
Correct.
Right?
Yeah.
If that's the client's wish.
Yes.
Okay. Understood. So immovable asset is 1% or 6,000 per title per lot, or immovable is 2,000. It's not income bearing. Okay, so there's paid out from insurance benefit is 30 ringgit per payment. This is for the medical, right? Is it medical?
For medical, or something they want to do cash withdrawal. That's what
also, cash withdrawal is 30 ringgit per payment. So, for example, let's say they bought a savings plan where they have some yearly withdrawal, and maybe they accumulate like 5 years later, then only they withdraw X amount, which is a portion of the total. So you charge 30 ringgit for per payment, right?
Correct.
Unless it's a lump sum, like let's say critical illness lump sum 500,000 out, then you will charge 2,000. Is it? This and this. Okay, sorry.
Because under F, it is for those cases where it's non-cash value, non-sum assured withdrawal.
Non-sum assured. Non-sum assured withdrawal. Okay. Sum assured there is 2,000.
Correct.
So okay, bonus, withdrawal cash value. Okay. And then after that, this is the LAFTA declaration. Okay.
Yeah.
So this also we need to tick. The client doesn't want to provide. If the client is like very
Yeah. So only if the answer is yes, you take. Otherwise, if there's nothing there, then don't bother taking lah.
So if the client is not cooperative, then we tick lah. They don't provide information.
Correct. Yeah, correct.
And the beneficiary is something weird, or the insurance premium is more than 50,000 per policy. Also we tick.
Correct.
Or value of the trust asset is disproportionate to the client's income, or the gross value of trust asset is more than 5 million. Gross value of trust asset more than 5 million.
Yeah, the gross asset of the trust is more than 5 million.
Wow. Okay. So if client from high risk country, and then if client is politically connected or family member, so these are direct politically connected person. How about son-in-law of a politician is connected?
Yeah, which comes to a family member of a
cousin.
Yeah. So it could be that's provided if we know. If we don't know, then it's fine. If we know, then we have to check.
Yeah. So okay lah. So this is the form that we tick lah. It's quite simple to fill out this form.
Yeah, quite simple.
Okay. Quite simple to fill this form, and a lot of customization can be done, right? We can write down all the customization. So this is a simple form, and then also I'd like to show you on the. This is the sample trust deed lah. Just roughly only blank out all the names. From this form, right, it will translate to this sample trust deed. So, whereas this main part is to talk about definition, okay, all this definition, and then declaration of trust, okay, how is it? Then the revocability. Just now we mentioned there's a revocability in here. Revocability here. Revoke here lah. Revocability, right? It covers here. Okay, protector. You see this clause? So here lah, protector. Power of protector. Once you fill in here, come out here. Okay. What are the roles of protector? Okay. Appointment of appropriate substitute trustee. Management of the trust asset. Okay. So for this one, is a translation of these two pages. If you fill up, so if you fill up these triggering events, and if you fill up the, let's see, this is the here, right? The movable property, the percentage, and the distribution part. So all this will be covered here. shall pay X amount for what, X amount for what. Okay, 80,000 per year for degree. Okay, study degree. So all this one is quite long. This trust deed.
Correct.
Okay, okay, finish already. Still on this management, and then okay, fixed nature of beneficiary's interest, expiry of the trust period, as we just now we cover the expiry. I think it's covered under expiry of trust deed is covered under here here the trust section number 5. We transfer to
Correct.
expiry of trust period, and then the cost, okay? And then the future provision. So this is a joint trust deed, so it's signed by 2 settlors. Okay, and then the schedule 1 is a trust asset. So here, twin trust asset. This one is trust asset number 2, life insurance policy, and then this is the beneficiary. So here, so beneficiary you fill up already in this form. Where is it?
Correct.
Yeah, fill up somewhere. I think up there. Yeah, in the form, Okay, and then protector. Then this is the power of trustee. Okay, this is all the power of trustee. A few pages lah. We mentioned the power of trustee, governing laws, validity. This is the definition of critical illness in schedule number 5, and then that's it. Plus the power of attorney lah. So I'll show you this. Okay, so this is the sample of power of attorney. Okay, this is a joint settlor. Okay, so this is the power of attorney lah. How it looks like about 1 irrevocable power of attorney lah, right? 1,
Yeah, correct.
2, 3, 4, 5, 6, 7 pages, which includes the trust asset lah here. Schedule number 1. And then power of attorney between who and who, the role trustee. So these are the 2 documents, right, that is needed to be
Correct.
signed by the client. So I think it's pretty straightforward. So we have covered the concept of the declaration of trust, and we have also covered what are the target market that you should be targeting. So summary is find someone that with minor children or elderly parents. Find some, your target client should be special child. And we go through the trust instruction form. And then we also roughly show you the sample trust deed and the sample power of attorney. Okay, so I open the floor, see whether Amanda got any question. Amanda, do you have any question? Hello? 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 Amanda? Hello? No question.
No question. Thank you.
Okay. Thank you for listening. So, Encik Azhar, do you have anything to
Thank you,
add on?
Azhar.
Welcome.
Okay.
No, I
So-
don't have anything to add.
Yeah. So the next round of training would be the how to sell my trust package effectively.
Okay.
Okay. So thank you,
Alright.
Encik Azhar. So next week,
Thank you.
sorry, next week is 5:30 to 6:30.
Say again, sorry.
The next week's training is 5:30 to 6:30.
No, it's not 4 to 5.
Because I have
Is it
another webinar 4 to 5.
is it the same 5:30 to 6:30? Is it the same for the 23rd?
23rd, 23rd is also 5:30 to 6:30. Yeah, lor. Do you have any problem with this time? If not, we can change.
No, I'm okay with it.
Oh, so yeah, okay lah. So both is 5:30 to 6:30 lah.
Yeah.
So okay lah. So it's see you next time. Thanks for logging
Okay,
in.
right.
Okay,
Thanks.
goodbye. Thank you. Bye.
Okay, bye.
The organizer has ended the session, and this call will be disconnected. Good.